Good morning, everyone. Welcome to our webinar today. I'm glad to have here Ed Bechara. Thank you for joining us today, Ed. Let's give attendees a couple of minutes. How are you doing, Ed?
Very good, Marco. I'm excited about today's session, and we're going to have a good discussion about E2s and EB-5s. That's something that you and I have done for many, many years.
Oh, yes, indeed. Many years and many lessons learned, which is
Yes.
the main thing. And I'm also looking forward to sharing a lot of practical uh, insights. I don't want to call it advice. You are the legal advisor. We are more of the business strategist, and we then tie strategy with the documents that attorneys, the business plans that attorneys need to win cases.
Mhm.
So let's give attendees a couple of minutes until they, for them to join, and then we'll get started with a very interesting program that we have today. So let's see, where are people joining from? I'm curious to hear. Let's see. Feel free to share in the chat where you're joining this webinar from. By the way, I am based in Miami and Ed is based in Orlando. Well, not exactly Orlando, right?
Yeah, we'll say the greater Orlando area, in the
Greater
Winter
Orlando.
Park, Maitland area, about 5-7 minutes from downtown Orlando.
Okay, fantastic. Wonderful. I would say let's get started, Ed.
Sure.
And let's see, I'm going to share my screen. And I want to again thank Edward Bechara for joining us today for this E-2 or EB-5 webinar. We're going to be talking about funding, business plans, and real case studies. Briefly, I want to introduce myself, but before I do that, I want to thank our marketing team who always does a fantastic job putting together these webinars. I know that there is a lot of work behind it, so I really appreciate their work. So, I am Marcos Cano, the founder, and as I like to say, orchestra conductor of Visa Business Plans. I have been an entrepreneur for more than 35 years, growing and scaling businesses. My educational background is in business, in finance. I am, by the way, Ed, I don't know if I told you, I am a Gator, got my degree in finance from UF years ago. And then I went on to get my MBA in Italy, then went back to school 20 years later to Michigan State to continue studying entrepreneurship and finance and venture capital. And more important than that, as an entrepreneur for more than 35 years, I've been in the trenches many times, again, launching, creating, and scaling businesses. And in 2009, when I migrated to the US under an O1 visa in entrepreneurship, I learned what an immigration business plan was. And I found it very interesting that immigration business plans are very unique documents that talk to an immigration officer or consular officer. And that's when I launched these business plans. And wow, time flies. In 16 years, we've done more than
Yes.
9,000 immigration business plans. We also do business plan for other purposes. When clients need a loan, SBA loan, or they just need a flight plan for the business, we can also help them with that. And in the years that we've been doing this, I've had the pleasure of working with Ed, and in many cases, and I have learned, I have to say, a lot from you, Ed. You have no idea how much I learn from you every time that we work on a case together. When I go to when I attend those immigration conferences and you speak on a panel, I'm absorbing knowledge and wisdom. So why don't you introduce yourself, Ed? Please go ahead.
Right. Thank you, Marco. And likewise, I've learned a lot from you, Marco. And, we've need business plan writers that know what they're doing. And Marco, you do know what you're doing. So as a brief introduction, I've been a US immigration lawyer now for close to 45 years. Started my immigration practice in Orlando. I'm originally from Australia. I was a lawyer in Australia. I have 2 law degrees from Australia, and I was pursuing a master's in international law. Then I came to the US in December of 78. My mother is American from Massachusetts, and we settled in Orlando because it's nicer weather down here. She had a brother and sister in Orlando. So when I said I want to practice US law, they said you have to go back to law school. So like you, Marco, I went to the University of Florida Law School, started in February of 1980, obtained my Juris Doctor degree, and then started practicing, as I said, in 83, just doing immigration, first immigration lawyer in Orlando. And been practicing business and family immigration ever since then. I went back to the University of Florida as an adjunct professor of business immigration law. And over the years, for 32 years, we've been involved in EB-5. 45 years E-2, 32 years EB-5. And as you know, Marco, I'm a member of different organizations that represent the EB-5 industry, like Invest in USA. We're involved with EB-5 Investors Magazine. So past AILA president of the Central Florida chapter, current chair of the Business and Investment Committee of the AILA Central Florida chapter. Marco and I are going to be in Clearwater in October for the annual conference, and we're going to be talking about EB-5s and E2s and L1s, etc. So I look forward to seeing you then, Marco.
I look forward to seeing you and other immigration lawyers and learn more about what's going on, new trends, and in the adjudication standards. So I want to quickly share with the audience that the program for today, the creative EB-5 funding. We're going to talk about it. We're going to talk about a conventional direct and EB-5s, holding companies and troubled businesses. And then we're going to be talking E2 to EB-5, what's doable and what's not. Then at the end of this webinar, we're going to be sharing a couple of case studies that we've worked on together, and we will have 10 minutes for Q&A at the end of this webinar. So let's begin with the well, this is a picture showing I don't know how many years back, but we met back in 2011, and we've been working on together on many cases since then. So time flies, but let's see, Ed, creative EB-5 funding. So what works, what doesn't work, what's compliant and what's not?
Yeah. Well, I think when we talk about creative EB-5 funding, if we're talking from the investor's standpoint, the EB-5 investors, they're going to say, well, look, if we do EB-5, we're going to either have to invest 800,000 or $1,050,000 from our personal funds, right? And when we are talking from an investor standpoint, they may say, well, look, we're going to invest this money at risk because under EB-5 laws, the investment has to be 100% at risk. There cannot be any redemption or guarantees for the return of the money. So creative EB-5 funding from an investor standpoint, I look at that, well, they're going to put money into the EB-5 business or an EB-5 regional center business, but it has to be their personal funds that they're putting at risk. But how do we say to the investor that if they invest at risk 100%, how do they protect their wealth? Well, creative EB-5 funding, if they've got the wealth to start off with, they may say, well, we've got money that we're transferring to the US and we want to protect our wealth. So the way that they can do that is putting their own money into buying real estate, could be townhomes in a community that's managed by a company. They're making that cash investment in a different type of real estate. They can then go to a mortgage company and then they get a mortgage on that real estate that they put cash into. They take the mortgage money out and then they put it into the EB-5, whether it's their own business or a regional centre business, which has to be at risk 100%. And then there might be management companies for the townhomes that they may have invested in that will rent out the homes. They get rental income for them to use as income to pay off the mortgage that they just got. But the reason why they may do that is that the real estate grows in value, right? And the rate of return on that growth of value of that real estate is far greater than usually sometimes the rate of return on their investment, especially if they're investing in an EB-5 regional centre project. The other way is that the foreign national can completely invest their cash into a bank, treasuries, bonds, money market accounts, and then go to the bank and say, we want to borrow against what we've just invested in. The bank will says, fine, here's the money that we're going to be loaning you. And then they invest that money as their personal funds into an EB-5 project. And then, of course, the money that they invested into money market accounts, treasuries, bonds increase in value. So as far as creative EB-5 funding from an investor standpoint, that's what I would recommend to clients, that we're not the experts in making sure that they invest in the right type of alternative assets, but they can talk to accountants, corporate lawyers to guide them through that process, Marco.
Okay, perfect. Are you seeing any other, have you seen any other type of creative financing out there, or is that the main one that you?
Yeah, I think if we're looking at, regional centers now that are creating how investors can invest in their projects, well, number one, with the RIA, Reform Integrity Act of 2022, it supported the concept of process of investing, which means that an investor can get funds, invest maybe $200,000 towards an $800,000 investment, and show that over the next several months they'll invest the rest. But they have to show that they've got the liquid assets that they can liquidate to come up with the balance of the EB-5 funds they need for the $800,000 investment.
Great, great. That's another avenue that investors can explore in doing an EB-5 investment. Thank you, Ed.
Sure.
So I wanted to talk briefly about, we specialize, of course, in writing immigration business plans that meet the requirements of the EB-5 space. So I wanted to briefly define, what exactly is a credible and realistic EB-5 business plan? Well, first thing is that I always like to underline that we're not immigration lawyers. We do not pretend to be immigration lawyers, and we do not provide legal advice or anything that looks or smells like legal advice. And of course, when we have consultations with clients, are asking us 1,000 questions regarding, can I do this, can I do that? We always send them back to the lawyers so that they can get the proper legal guidance. But when it comes to writing compliant EB-5 business plans, we have to be kind of immigration law nerds. So we're familiar with the policy manual and adjudication standards. So first thing what we do is make sure that the business plan is compliant with INA 203B5, and of course the precedent decision matter of the whole. We also take a look into the matter of Izumi that touches on the investment and so on. But what makes, in our experience and our view, a good business plan for an EB-5 is detail, beginning with a detailed operational and marketing plan. Second, detailed competitor analysis, right? The matter of how says, don't just tell me who your competitors are. Shows me, what makes you different. I want to know about your competitors' pricing strategies, services strategies. So they want, again, details. It cannot be a vague, description. They want all those details in the business plan. Now, when it comes to the investment breakdown, it's important to show the total cost to launch the business. If we're, talking about launching a business, we could be doing a plan for someone who's buying an existing business, right? So in that case, we will break down not only the investment to purchase the existing business, but potentially if there will be an additional investment to grow the business. And last but not least, regarding the investment breakdown, we always want to include or make reference to capital sources, right? Which takes me back to what Ed was saying, right? Where did the money come from, right? And that's where we work as a team with the immigration lawyer to make sure that that investment is compliant with immigration law. That's something that the lawyer determines. And of course, we want to show commitment of funds. Just showing the intent to start spending money in the future is not enough. They want to see, as I like to say, some sort of a skin in the game, meaning show me that you're in the process of, using these funds to establish or grow the business. When it comes to financial projection, it's key. And the project we believe in is we have to be ready for an officer who might want to challenge the basis for the financial projections. If we're projecting, for example, $1 million in revenue for 2025, this is just an example. Okay, where did the numbers come from? So we take care and use a lot of resources making sure that the financial projections use assumptions, right? So that's key. And the most important thing I believe in the business plan is showing that the new commercial enterprise or the job creating entity will create or preserve at least 10 permanent full-time jobs, right? What I want to highlight here is that the focus is on details, not the length of a business plan. Sometimes clients say, oh, but I've seen 70, 80, 100-page business plans. And I say, look, based on my experience, an officer will not have the time to go through 100 pages. And if you're concise and you focus on the details and on the things that the officers are going to be looking at and looking into, length is not the name of the game. It's sufficient details. The more details, the better. Now, talking about what we find is the most important section of the plan, it's showing the nexus between the investment and the job creation. We believe that when an officer is reviewing the plan, they will be asking basically 3 questions. Number 1, is this business feasible? Number 2, are the assumptions reasonable? That's why, again, we have to back up every single projection with a verifiable industry benchmark. And third, the question, especially with a new business, is how likely is a new commercial enterprise to create the 10 qualifying jobs or not, right? So we want to always lean towards increasing the likelihood that it's going to happen. And again, within that context, and talking about the nexus between investment and job creation, it's important to show a timeline that connects again when the investment is being deployed and the actual creation of jobs. And again, for that, we use industry benchmarks, and we're going to make sure that those projections are backed by and supported by market analysis and industry standards. This is what makes a business plan credible and realistic. Now, on to the next topic, unconventional direct EB-5s, holding companies with subsidiaries and troubled businesses. So, Ed, go ahead.
Yeah, I think that with direct EB-5s, and when we talk about in today's world, after the RIA of 2022, the 2 different types of EB-5 projects is EB-5 direct, where an investor puts money in usually their own business, or they could put money into a business that is managed and controlled by a separate developer. If there's going to be more than one investor in that particular project, that location of that project, well, then it has to be under the umbrella of a regional center, right? So if we're talking about one investor per location for that business project, it's an EB-5 direct. And it's based upon the amount of investment, is the location of that business. And of course, Marco, if I say to you, we have a potential client that want to start a business in this location, here's the street address, Marco will come back and say, yes, this is a area of high unemployment, it's a TEA, or it's a rural area, for example, and therefore it only requires an $800,000 investment. So unconventional direct EB-5s. Well, let's first of all look at a troubled business. Well, troubled businesses, first of all, what I would ask the investor, why would you want to invest in a troubled business, right? Because the troubled business, as Marco has defined, is an enterprise that has been in existence for at least 2 years and has incurred a net loss during the 12 to 24 months period of at least 20% of the business net worth, right? So the business hasn't been doing that well. And someone may want to invest in a troubled business, right? And because they like the location, they like the nature of the business. But the other good news about investing in a troubled business is that if they already have hired US employees or permanent resident employees, they can count those employees, right? So if there's a business that was already employed 5 or 6 employees that are either US citizens, permanent residents, they're full-time, and then they're putting more money in and investing in a troubled business, they can count those existing jobs towards the 10 job count. They don't have to employ all 10 when they file their EB-5 petition, but in the business plan, as Marco would point out, that over the next couple of years, the additional employees, full-time employees, will be hired. So troubled business, again, we are immigration lawyers, we're not business advisors. So Marco and I would probably say to the investor, have you talked to your accountants, CPAs, financial advisors, as to whether this is a good decision or not? We're not going to make that decision for you, but from an immigration legal standpoint, yes, you can do it, but, and these are the advantages. As far as holding companies and subsidiaries, many years ago, we had a company that said we want to bring in investors, and then we want to bring in a whole bunch of investors in the new commercial enterprise, and then for each investor we're going to place them in a business that's going to be located in a certain geographical area. But they said, to the US Immigration Service, we want to bring in 20 investors right now. We've got them available. They're going to come and deposit their money into the new commercial enterprise. And then we're going to show that the job creating entities will be established over a period of time. And for this one investor, we're going to put the money into this one job creating entity. And then the government came back and says, well, wait a minute now. Do you have the locations of the other businesses? And they said, no. They said, well, we cannot accept this NCE. We cannot accept all this money coming into the NCE where you do not have the location of these various business entities. So as far as a holding company, yeah, probably, the EB-5 money can come into a holding company, and then that holding company can have a US subsidiary where they're directing the $800,000 into that US subsidiary so that US subsidiary can create the jobs. But if we are going to have holding companies and subsidiaries, all the subsidiaries and their business activities have to be located. The companies have to have an idea that they're going to start operations today, not tomorrow. And so a holding company receiving EB-5 money, the subsidiaries have to have, as part of the business plan, their readiness to start operations, not something that could be done in the future because the government won't accept that. Marco, do you have a comment on that?
Yes, look, I wanted to go back to the troubled business, scenario where, yes, I agree. The first question one would ask is, why would someone want to invest in a troubled business. Where the reality of things is that we beyond writing business plans, or even before writing business plans, we I mean, I've been a business consultant for 20 years and business coach since 2009. And, basically, when you look at a business, you have to understand, okay, why is it in trouble? There's basically, and I want to maybe oversimplify things here, one of the reasons could be the business itself, that no matter who's running the business, it's by either a bad location, it's bad time, or a bad business to be in,
Yeah.
right?
Right.
Or it could be, a business that the problem is not the business itself, but leadership and who's running the business. Let me give an example. I was in the restaurant business for more than 25 years. And it's you see a lot of statistics and people saying I don't get into the restaurant business because it's very risky. Yes, when you look at the statistics, there's a high failure rate. When you analyze why such a high failure rate, where well, it's a business that requires certain skill sets. You need to be super organized. Whoever is running a restaurant has to be on top of numbers every single day. So if that discipline is not applied in the restaurant business, it can go out of business fairly quickly. So why would someone invest in a troubled business? Maybe it's the business, but maybe someone is finding a diamond in the rough. Finding, look, this is a great business. The problem is that it's being mismanaged. Or just let me give another example. Every single every single day in the United States, about 10,000 people reach the retirement age. So you have this wave of people retiring or wanting to do, something different with their lives, and they're selling their businesses that maybe they're not really as driven to run those businesses as they were 10, 20 years ago. And, that's where you see a business with good bones, but it's just not being managed properly. So
Right.
that,
And then, yeah, yeah. And also, Marco, don't forget, if the EB-5 investor says, oh, we want to come in and buy into that business, well, if they buy the stock of that business, then they're buying maybe into the liabilities of that business.
oh yes,
And that could be in all different shapes and forms. But if they say we want to be an EB-5 investor, but we don't want to buy into their liabilities, well, then create your own US corporation. That US corporation will buy the assets of that business, which can count towards EB-5, but you're not buying the liabilities. You're starting your own US corporation. Yes, now you'll have to show the creation of 10 new jobs, but that's going to be a financial decision that,
hmm,
yes, I can invest in a trouble business, buying the stock and buying the liabilities and buying all the troubles that go with it, or set up my own US corporation, put the money in my own US corporation to buy the assets and not taking over the liabilities. Right.
exactly,
So I think that sometimes it's not just me and Marco, but it's the accountants, the corporate lawyers coming in to,
exactly,
as we normally do, have a plan of action, have a strategy meeting, analysis, and decide which is the best way for the investor to go.
exactly. Yeah, and that's exactly what we always advise clients to do. Yes, we help many clients identify, business opportunities according to their profile, risk profile, and how much money they want to invest, how much money they want to take, how much hands-on or hands-off they want to be. I mean, there are many variables that go also into the features of success of a business. But then, yes, as you're saying, Edward, we bring in the experts, the accountants, the lawyers, and so on, so that they can conduct a proper due diligence to identify any potential skeletons in the closet, right?
Right.
In case they're buying the shares of an existing business. So in summary, it's doable, but you have to know what you're doing, and the key lies in surrounding yourself with the right professionals. In talking about troubled business, as Ed was indicating, that this is the definition of a troubled business, right? In the EB-5 context, net loss of at least 20% of its net worth in the last 12 to 24 months prior to the I-526 petition, right? And the interesting thing is that to meet the requirements, that EB-5 investor has to make sure that the job creating entity either preserves 10 jobs, or if, for example, they have, as Ed indicated before, if they have already 8 jobs created, they have to preserve those 8 jobs and create at least 2 more. So again, it requires someone who knows what they're doing, but it's, we've done, a few very interesting business plan for this type of scenario, the trouble business one, and I found that 100% of our clients, they're more of the sophisticated and super experienced business owner and investor type, not the business owner who has never done business here in the States, or someone who has maybe limited experience in business. Okay, let's switch to another topic, which is E2 to EB-5, that I know, Ed, is a topic that you particularly like. And I have to say that, yes, I also think that it's an interesting opportunity for many E2 visa holders, as long as they understand the path from E2 to EB-5, and that they work with someone like Ed, who has guided many clients successfully in this path. So I'm curious to hear from you, Ed, what do
Sure.
regulations say and adjudication standards?
Okay. So E2s I've been handling now for 45 years, since 83. And, to be an E2 investor, of course, you have to be a citizen of a country that has a treaty with the US or international agreement, right? And if you are a citizen of one of these countries, then you can invest in a US business, either buy the assets of an existing business, buy the stock of an existing business, or create your own E2 business. And I know that we've worked with Marco over the years to establish the E2 business plan. So the minimum investment requirement for an E2 doesn't really exist, but what the US immigration laws and regulations and policies support the concept of what would it take to start a business of this nature? What would be a substantial investment for E2? So if it takes $100,000 to start a business, then that's your E2 investment. And with the E2 investment, it also requires a showing to the US CIS or the US consulate that this is an investment that has been irrevocably committed. So again, we have to authenticate the source of funds of the investor who's going to be making the investment in the E2 business. Where did the money come from? Is it from lawful sources and the path of funds? And then it goes usually from the personal account into the E2 business. But to show that it's irrevocably committed, a lot of investors, whether it's 100,000 or 200,000, they say, well, look, if we're investing and we're spending money on furniture, equipment, inventory, on the deposit on a lease, and we're spending this money to show that we've made an E2 investment, what if we don't get the E2 visa? So Marco and myself and the corporate lawyers and the accountants will set up a irrevocable contract, irrevocable trust account, which means that the money goes into the trust account. The corporate lawyers, when they hear news that the E2 visa is granted, and now that they've successfully entered the US under an E2, then the money will be released by the corporate lawyer over the irrevocable trust account, released to the various people that are going to say, well, we're supplying the equipment, furniture, inventory, etc. And the deposit will go to the lease arrangement. So it will be conditioned upon the E2 approval, all right? Because it has to be irrevocably committed in the beginning. Now, E2 to EB-5. If someone says, well, we want to establish an E2 business, and then one day we may want to convert our E2 business to EB-5, we'll say, okay, then we can talk about maybe one day. But remember, when they're submitting their E2 visa application, the investor, to the US consulate or the US Immigration Service, they have to clearly show, and in writing, that they have the intent to depart the US after their E2 visa and status expires. They have the intent to depart and go back. So, one has to be very careful in advising a client that they cannot say, oh, I have an E2 intent, but I also have an immigrant intent, because then that's a contradiction of what they need to show the US consulate, that they need to get an E2 visa with the intent to depart after the E2 status is in the US. But if they're saying, well, we're thinking about it, well, okay, they could be thinking about it. But so we would go to Marco and say, Marco, if they want to convert an E2 business, that they're making an investment in an E2 business and use that E2 business as a foundation for EB-5, well, then, of course, we have to discuss what are the EB-5 requirements. And if it's EB-5 direct, which means that they're the only investor in the business, is that the investment that's going to be made into the business, yes, initially the E2 $100,000 irrevocable commitment, but the balance, and if it's in a target employment area or rural area, which is 800,000, so the balance would be 700,000. Now, with EB-5, you don't have to show that when the money goes into a business is irrevocably committed. You have to show through the business plan, as Marco will explain, that the money will be used over a period of time, maybe a couple of years, to show that it will be used for the following purposes. And then the nexus between that EB-5 money going in and the job creation, right? So the good news about EB-5 doesn't have to be irrevocably committed today, but in a plan, in a business plan, how it will be spent over the next few years. So E2 to EB-5, yes, but we have to be careful of the E2 laws, the E2 requirement of intent to return home, and also EB-5. Now, very quickly, if someone's already in the US under E2 status, and they say, well, look, we love it in the US, we're here, now we have changed our mind, and they've been in the US maybe for 3 months at least, and they say, we want to convert our E2 to EB-5, you can. If the priority date is current, which means that there are available immigrant visas for EB-5s, then while they're in the US, they can file their EB-5 petition and concurrently file their application for the green card and get work authorization permission to travel. Right, so it can go from E2 to EB-5 under the right conditions. Marco?
Yeah, I wanted to go back to the trust account idea, which I love, by the way, but it has to be executed correctly. So, have you seen over the years, Edward, either from the USCIS or from any U.S. consulate, any pushback on those trust accounts, escrow agreements for E2s?
No, I've not seen any pushback at all,
Okay,
because
okay,
I think that we'll bring in the corporate lawyers that will make sure that we're showing that the money has been spent, and that's money in an escrow account, and the irrevocable contracts means that the investor does not have control over that money anymore. Once the money is invested and transferred from the investor to the corporate trust account, it's under the control of a corporate lawyer, usually, that when they hear news that the E2 visa is granted and the investor has made an E2 entry, then the corporate lawyer will release those monies to the right people that the investor is using to set up an E2 operation. Well, I want to sell certain goods. Well, these are the supply of goods. I want computer equipment. I want furniture. You have a contract. And the contract will be with the landlord, with all these various entities, to say that, yes, we have signed a contract with you to buy this, but we condition the purchase on the granting of our E2 visa and our E2 entry, right? So we have not seen any pushback, no.
wonderful. For me, it's being able to use an escrow agreement to meet the E2 investment requirement is, for me, that's a no-brainer And since I've been an entrepreneur for so many years, I know how our clients think.
Right, right.
When they say, "Oh, what do you mean you have to invest before they get me the visa?" And I say, "Welcome to the E2 world." So, but then there's a portion of those potential clients who end up not doing anything because they are concerned that the
Sure.
E2 will not be approved, and then they go, "What do I do with my $100,000 or $200,000 investment?"
Yeah,
So being able to use the escrow agreement and the trust account for me it's brilliant. It really can open the door to many investors because then they're managing the risk. And
exactly,
for
exactly.
me, whatever they pay for the escrow agreement is like paying insurance, right?
Yeah.
Against not being approved, right?
Well, put it this way, like we represent clients, and thank goodness, that as long as I work with you, Marco, we've never had a denial on any E2, right?
Correct.
So basically that's the good news. And these processes work. So even though we may say to our client investor, we've never had a denial, but they still want to have that comfort level, right?
Exactly. Yes, that's so true. Okay, so I want to briefly talk about the pitfalls to avoid in an E2 to B5 business plan. Again, I want to underline I'm not an immigration lawyer and I'm not providing legal advice. I'm just providing, very practical insights, having done, as I like to say, more than 9,000 cases in 16 years has been my PhD in immigration from a practical perspective. So when we're working on an E2 to B5 case, as Edward said before, we are extremely careful when it comes to making sure that the investment qualifies for the EB-5, right? Um, and so we interact with the immigration lawyer working on the case. And that means that one of the main things I want to make sure that the investment is documented the right way and that the path of funds and source of funds is clear and ideally easy to demonstrate. And this
Yeah.
is
And
what again.
Marco, just to interrupt, I
Mhm.
think that the listeners and the attendees, we have to make it very clear that when we show the authentication or source of funds for the investment, we usually end up with what the government has required. And, of course, I always say, well, what is reasonable is on this hand, what it makes a lot of sense is over here, and what the government requires is over here. So when
Mhm.
our client investors say, oh, I can supply 10 pages to show where I got the money from, then we have to say, but based upon our experience dealing with the USCIS, this is what they want to see. So what qualifies? We usually end up with 8 to 10,000 pages to support authentication of source of funds, right? Is that reasonable? No, it's not reasonable. Is that what the government requires? Maybe. But it's not just 10 pages, So again, this is the dilemma, is that what qualifies is what the government wants to say qualifies. They always talk about preponderance of evidence, which is a low standard. If you have to supply 10 documents and you supply 5, they should approve it. But then they come back and say, maybe in a request for further evidence, we want to see another set of documents. So out of 10 documents, they may want to show 8 or 9 documents they accept, which is wrong, So we have to be very careful when we go back and supply extra information documentation. We mention preponderance of evidence, which is the standard, but we don't say to the USCIS, you're wrong, because they're the ones making the decision on the client's case. So when we talk about what qualifies and how do you document, it's what the government wants to see more than legally what is required. Sorry to interrupt, Michael.
But that's a great point, and again that reinforces the concept of we always work hand in hand with the lawyer to understand how they view the case and how they want things documented and shown on the business plan. Again, going back to the E2 to B5 business plan, super important the nexus between job investment and job creation, the concept is cost effect. So this is when the investment was deployed, and this is where when each position was created, it has to make sense. There has to be a connection between those two. Weekly, as many as you know, or all of you know, no 1099s, only W-2s. That, and full times means at least 35 hours per week, and jobs have to be permanent and not intermittent. That's
Yeah.
extremely important.
And then one additional thing, Marco, is that if we're
Yes,
talking about E2 to EB-5, remember, we're talking about the fact that each employee, if it's EB-5 direct, has to be either a US citizen or permanent resident. And so now the investor running this business has to ask, I want proof that you're a permanent resident or a US citizen. I need those documents, right? And
exactly.
usually when you
Yes,
fill out a 99, it doesn't really ask for proof that they're either a US citizen or permanent resident, but you have to ask if you are going to use this business for EB-5 purposes.
exactly. Great points. Great point. And so we quickly want to talk about case studies. One of them was an E-2 case, an interesting one. Going back to the holding company concept, our mutual client had a holding company that with two underlying subsidiaries, each one of them creating 5 jobs. One was a property management business, and the other, or second subsidiary was active in the business consulting, business incubator space. So that's an example of how someone who cannot envision investing in one single business that will create the 10 jobs, maybe they're perfectly capable of creating two smaller businesses, each one creating 5, and they can meet the 10 full-time permanent position requirements. Any thoughts about this, Ed?
No, I think you mentioned, and we mentioned before, that the two subsidiaries have to starting to exist at the same time. You're relying on the subsidiaries continuing to exist because,
Mm-hmm.
as you know, with the EB-5, you file your EB-5 petition. By the time you get your green card, it will be maybe a year later at least, and then you have your conditional green card for 2 years. And then towards the end of the 2 years, you file a petition to remove the conditions under EB-5 to show that your investment was sustained in the businesses and the jobs were created, right?
Exactly.
So that's why when one is making a decision on investing in a holding company with two subsidiaries, the two subsidiaries have to continue to exist. And so you have to have enough confidence, or as the investor, that these businesses will be viable, will be sustained for this length of time.
Exactly. That's that's key. That's why we always tell clients, don't get obsessed with finding the right business to get your visa. Let's think about getting the visa and being able to sustain the visa over time than to keep the visa over time. Because what's the point of going through the process, investing a lot of money, resources, bringing your family from overseas, starting a new life? So a lot of things changing, and then being unable down the road to, if you're going for the EB-5, to get the permanent green card, or if you're going just down the path of an E-2, getting that E-2 renewed. So again, it's key
Yeah.
to
Right.
focus on.
And then also, don't forget to run any business or create any business. It requires a lot of uh, dollar amounts, investment amounts, as you know, Marco. So, to do E2 to EB-5 and having two subsidiaries, it involves twice the work, right? So the investor has to understand that.
Exactly. Thank you. And then years ago, we did to work together on an interest in EB-5. Was a Chinese investor who created a golf instruction and on course training business where, out of 10 positions that they created, 2 of them were operations manager and administrative slash sales manager, and then 8 full-time golf instructors.
Yes.
That was years ago. That's a quote unquote easy business, right? Although there is no business that's really easy, right? But let's say it's less complicated than definitely than running a restaurant. That's for sure.
Yeah, and also a lot of people say, well, can we do this from our house? Can we do this from our home? We would recommend from the beginning with this E2 or EB-5, no, have a location, have the concept of where these people are going to be employed, because we know that with EB-5, the geographical location of your business dictates what your investment would be, right?
Exactly. Yes, that's
So I think that becomes important, that the location is where there's going to be activity, business activity, and where the employees are going to be, right?
exactly great. Thank you. So we now open the Q&A part of the webinar. Let's see here if please feel free to send your question through the chat. Let's see if we have any questions here. Okay. Okay, so we have someone asking, and you and I were talking about this before, that asking, okay, can I, if I have an E2 business that is making a lot of profits, can I reinvest those profits
Yeah,
into the E2, or even, into, the E2 entity, and make it into an EB-5 case?
yeah.
So what are your thoughts?
Well, I think that the easiest way to answer that, Marco, as you and I discussed, is that when we are talking about an EB-5 investment, usually it's a personal investment from the investor into the business. It's coming from their personal account into the EB-5 business. So if they have an E2 business and they've made money, well, the money has to leave that E2 business. We bring in, let's say, the corporate lawyers, the US certified public accountants, and they have to show that the money has left. It goes now into the personal account of the investor, right? EB-5 investor. And then the EB-5 investor will then transfer money into the E2 business to create an EB-5 business.
Perfect.
Like,
Thank you. Thank
you
you.
know, but I think that's the easiest way to do it. It can't just say, well, I've got retained earnings, I'm owed this money, I want to keep it with the EB-5 business. I think the easiest answer we can give, the easiest answer is that the whatever money leaves the E2 that may belong to the personal investor goes to the personal investor's private account, showing how he earned that money, and then he can reinvest it into the E2 business to create the EB-5 business.
Perfect. Thank you. And we have another question, and this is perfect for you. What entity do you use for the escrow agreement? Is it a bank?
Well,
Who
the
handles
the
that?
escrow account is under the corporate name. So if you have a corporation and you open up the escrow account under the corporation, right? So it could be in a bank, sure. Would you say open up an escrow account in the name under the corporate lawyers business? Well, yes, but I would say the easiest thing to do is the corporation will have an escrow account, and then the corporate lawyer will control that escrow account through an escrow agreement that's irrevocable.
Okay,
Okay.
perfect. Thank you. Another question, and this is for you as well. With E2 to EB-5, with a client coming to you saying that they want to create an E2 and then convert to an EB-5, how do you approach the intent issue?
Yeah, well, you have to be very, very careful. You can say, look, right now, today, if you are investing in an E2 business and you're applying, especially at the consulate, you have to sign a statement to say, my intent is to return to my home country after the E2 business. Okay. And that's your intent at the time that you've applied for the E2.
Mhm.
So when the client comes to you, Marco, and myself and says, well, we may think about and contemplate that the E2 business could be the basis for the EB-5, we can discuss and consult, and we can say, look, if you want to use an E2 business for an EB-5, this is what needs to be done. but it's consulting. The individual investor has not 100% decided that they want to go and come under an E2 and then convert to EB-5 and not go back to their home country. So it's all a question of intent. It's a question of documents, a question of what they're telling us, right? I don't want to have an agreement with a client that says I'm doing E2, and then in the same agreement, well, I want to convert my E2 to EB-5. Could you help me with this? As an immigration counselor, I won't sign an agreement like that. No, because it's a contradiction.
Okay. Thank you. Thank you, Ed. So a couple of more questions here. I'm going to take this one, Ed, if you don't
Sure,
mind.
of course, of
Of
course.
course, feel free to add your wisdom.
Yes.
So what's your opinion on doing a business plan with AI, ChatGPT? So that's an interesting one. Of course, you can save money and time. However, as I always tell clients, what is the issue with that? Let's quickly talk about how does ChatGPT work. It basically goes online and finds all the information that is available out there, right?
Yes.
But what is the issue with that? Immigration is a field that is always evolving, especially now under the new administration. Things could change by the day, right? So that the internet will never have that uh, the most updated trends, adjudication standards, and so on available for ChatGPT to be able to grasp, to gather that information. Second, an immigration business plan. Let me give an example. When we do an E2 business plan, the first question that we ask is, where are you filing the E2? Why is that relevant? Well, if you're doing a change of status, that's going to be through the USCIS. So there's no limit on the number of pages, right? But for the whole petition, that means that, we have no cap on how many pages the business plan should have. But not only that, most E2s, right, are processed overseas through U.S. consulates. So immigration officers in the U.S. do not have the exposure, right, to E2s that definitely consular officers have. So, but then each U.S. consulate is like its own kingdom. So you're finding in London, they have certain requirements.
Yeah.
Madrid, for example, we're writing 3-page business plans.
Yeah.
ChatGPT will never know that. And again, what's relevant and what officers look at and look into, that's something that only experience can give you.
Yeah.
So
Yeah.
any thoughts on that, Ed?
Yeah. Like again, as you said, each consulate has their own requirements for what they want to see and a page limit, right?
Mhm.
And so, like you and I have done, we say, okay, for this particular consulate, this is the order of exhibits. Let's make sure that we're consistent with the order of exhibits, and then we supply what the government wants to see, right? But, unfortunately, um, sometimes you don't get the entire message out to the consulate because of their page limit numbers, right?
Exactly. So there are a lot of nuances, right? For example, if you file in Buenos Aires, they're really big on the source of funds, like super big on that. Again, will ChatGPT know that? No, it won't. So I'm sharing my screen again. There you can find Edward Bashara's information and Visa business plans information. We have the QR code. Feel free to reach out with any questions, comments, thoughts. We're here to strategize and help you, you know, win more cases. I think we have time to a couple more questions real quick.
Sure.
We have here, in the legal frame of an E2, any comments about businesses such as marketing that could be handled remotely? I'm assuming, overseas. I'll give my 2 cents on from a business plan perspective. So when we're writing a business plan, if we see or envision that the business can be managed remotely from anywhere in the world, that's a red flag. Because for us, the officer might say, why do you need the visa? You can continue running this business from overseas. So we need to find arguments and real business reasons, right? Why the presence of the E2 investor is required in the United States.
Yeah. And
Thoughts, Ed?
yeah, like, I mean, put it this way, one of the legal basis for a denial of an E2 is that it's a marginal investment. Marginality is based upon the fact, what is the likelihood of not hiring US workers?
Mm-hmm.
And so, again, I would want to be conservative with the client, have an office location, don't operate from your house, have an office location where there could be potential hiring of US workers, whether full-time, part-time, even independent contractors, and then you're showing that the business is going to be real, operating, and not marginal.
Okay. Thank
Okay.
you. Talking about marginal, there is one last question that I'll leave this one for you. It says for E2 investment, what constitutes at risk and non-marginal? For example, if creating a US logistics company and invested funds into purchasing a temporary office with intent to invest more, purchase warehouse and so on, after two applications submitted, might that be enough investment or is that passive? That's how the question is written.
Yeah, but I think that we bring in our team of professionals. Like, I mean, if a client came to me with that question, I would bring in Marco, I'd bring in the business plan corporate lawyer, bring in the accountant. And, if we're saying you're investing a certain dollar amount, is it going to be a balanced investment, right? Is it going to be on inventory? Is it going to be on furniture? Are you establishing an infrastructure to show that there will be the hiring of workers, an infrastructure that there will be real business activity, and how is that money going to be spent, right? So if you say in the business plan, Marco, well, the investment amount is going 99% into inventory, well, but how are you going to manage that inventory? Do you need computers? Do you need equipment? Do you need a location, right? So it has
Exactly.
to be a balanced investment.
Exactly. By the way, it's past 1 p.m. So
Yeah.
we understand if you guys, attendees have to leave. We're just almost done. You're going to share my thoughts on this. How do we approach the investment section of an E2 business plan? First thing is we're going to make sure that the investment can support the concept of, okay, my company is ready to conduct business tomorrow. I'm ready to go. All I need is a visa. Number one, of course, when I see the commitment of funds, but in our view, any promise of future investment, it's nice to have, but like any promise, it can be broken. There is no certainty that any future investment or any future capital will be deployed. Again,
Right.
it's nice to have, but what counts is show me the money, show me that the business is ready to be operational, or maybe that the business is already conducting business and has hired the staff and so on.
Totally agree, Marco. Totally agree.
Well, thank you. Thank you to all the attendees today. Thank you, Ed, for joining us in this webinar today. We really appreciate your time and your insights and wisdom and everything that we have learned over the years from you and your office and your wonderful staff. We wish you all a great rest of the day and a great weekend. Thank
And,
you.
and my pleasure, and the feeling is mutual, Marco. Thank you.
Thank you. Thank you. Bye bye.
Goodbye.